What strategies and methods can an attorney bring to bear to try and expedite the slow VA process? Because, really anybody claiming that they can speed up a VA disability case
is probably not being truthful, yeah. And unfortunately, there are a bunch of scammers out there who tell that story to people and then just take money. But that's a different thing. In terms of expediting claims, there are a couple of ways that you can go about it. One is there is a formal process with VA for expediting claims, and that requires you to meet their criterion. For example, if you're 75 or older, the Board of Veterans Appeals will expedite your claim. If you are diagnosed with a fatal condition, the VA will expedite your claim.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA, your guide to unlocking your VA disability benefits. If you're a veteran applying for VA benefits, subscribe to our podcast for the latest developments in VA disability. So welcome, I'm Francis Jackson. This is Kristian Terrison. This is our podcast for veterans who are dealing with VA disability issues. Every week, we provide insights into the VA disability process and how it can be made to work in your favor. So who is this show for? Well, it's for veterans. But it's not just for veterans. It's for veterans' families. It's for veterans' friends. It's for folks in the community who want to support their veterans. So, folks, if you know a veteran who is having difficulty with his VA disability compensation, this is the podcast for you. Today, we're going to talk about the role of an attorney in helping veterans with their VA benefits claims.
All right. Well, to begin with, what are some of the most common obstacles that veterans are facing in their disability claims where you see that an attorney can make a difference?
I think the one that is most common is that veterans don't understand, or in some cases just can't get, regardless of whether they understand, the need for a medical explanation of how their current disability relates to what happened in the service. That is the number one problem that we see over and over again that leads to denials by the VA.
I guess, can you give an example of how having an attorney in that situation has changed the outcome of a claim?
Sure. It happens all the time. But what happens is we'll get a claim for a veteran, been turned down by the VA, and look at it, and I think the ones that we handle the most often are claims for mental health issues, especially PTSD. And what will happen is the veteran will go to the VA, he'll make a claim, he'll tell them what happened in service, he'll send them the medical records showing that he's been diagnosed with PTSD. But the VA will say, there's nothing here that demonstrates how your current diagnosis of PTSD is linked or related to your service. And the way that we can fix that in most cases is to get a psychiatrist or psychologist or mental health counselor or someone else who's a medical expert in that field and have them interview the veteran and then write a report explaining to VA what took place in the service and how that's connected to the current mental health issues. And, it has just reversed the outcome in so many cases where we've done that.
Now, VA regulations, rules are notoriously complex. What are some of the most common ways that you're able to help as an attorney when navigating the VA disability system?
Well, here's another example. The VA has a special provision that makes a huge difference in veterans' compensation. It's 38 CFR 4.16 if you want to get technical, but the bottom line is what it does is to say that if a veteran has service-connected disabilities that don't rise to the level of getting a 100% rating on the rating schedule, they can still be paid at the 100% rate if all of their service-connected disabilities, taken in combination, prevent them from working. Now, VA is very fussy about the application of that regulation. And what we've been able to do in many cases is to hire a vocational expert, someone who's expert in the world of work, and get them to write a nice report explaining how the combination of the veteran's disabilities prevents him or her from being able to work full-time and support themselves. And that's just another example of ways that these regulations can come back and preclude veterans from getting through the bureaucracy on their own. They simply don't have the expertise necessary to solve these problems in many cases.
Well, certainly when the VA sends you the long boilerplate letter explaining why you were denied, why would you doubt it if you weren't versed in this stuff?
You mean when you get the 38 pages of fine print?
Indeed.
Yeah, these statements of the case sometimes are just impenetrable.
Can you discuss the role of an attorney when it comes to gathering and presenting evidence to support a veteran's disability claim?
Sure. There are really two sort of starting points, if you will, for gathering the information. One, obviously, is talking to the veteran himself or herself. And that's the preferred place to start as long as the veteran is still able to communicate. Obviously, if you have someone who's had a bad stroke or has other problems and is no longer able to communicate, or you have a situation where you're representing a widow or a widower, then that's a different problem. But we start generally with talking with the veteran and trying to get all the information, identify the key issues, and kind of hone in on them. In addition to that, we get the veteran's claims file or C file from the VA. And that, I have to say, the VA has gotten much better about that. It used to take literally years to get those files. Now, typically, we can get them in 3 or 4 months, which is a huge improvement. But we go to the file, review the entire file, look at what the claims were that were made, why they were turned down, and what information is in the file that bears on them. The second thing that we do is, I think, in some ways more important. We get the military personnel file, and I can't tell you how many cases we've had where the information necessary to prove the claim was not in the C file, but it was in the military personnel file. Just as an example, we had a gentleman who was stationed in Germany, and he filed a claim with the VA for some orthopedic injuries, and he said that he'd been seriously injured in a car accident in Germany. Nothing anywhere in the claims file supported that. But when we got the personnel file, lo and behold, tucked away in the personnel file was a reprimand for getting into an accident with a military vehicle that established that, in fact, he had been in an accident in Germany, and that was the cause of all these problems. And there's nothing in his claims file about that. But in the personnel file, it was right there.
How about when an initial claim is denied? What are some of the ways an attorney can assist there?
The most basic thing that we do when a claim is denied is to look at why it was denied. The VA is this very large bureaucracy. The VA is actually the second largest department in the entire government, behind only the Department of Defense. I mean, it's that big. And when it's that big and bureaucratic, it's often difficult for an individual to communicate with the VA and understand what the issues are. So when we get a case where the person's been turned down for benefits and has come to us for assistance, the first thing we do is to sit down and read the decision and look at the language that the VA used in turning it down and see if we can't identify the critical pieces of information that are missing. Once you've done that, then it certainly simplifies what you need to find by way of information to establish that the VA was incorrect in turning down the claim. And it can be a variety of things. Often it's a lack of medical connection, as I mentioned earlier. It can be a lack of vocational support for TDIU, as I mentioned. But there are other things. For example, we've had a number of cases over the years where the VA said, well, yes, we know that you hurt your back in the service, but that was just a minor thing. You recovered, you were fine, and then years later you got hurt in an industrial accident. And that's really the cause of your problems, and why are you bothering us? They don't put it in quite those terms, but that's the essence. So what we are often able to do in those cases is to develop the information showing that, in fact, the veteran was suffering from back problems before the industrial accident. And while that may have made the back problems worse, that was not the cause. That the original injury in the service was the cause, and there were continuing back problems even before the industrial accident. That's just one example, but it's often possible to collect information from people who knew the veteran before and after certain events to demonstrate that the VA's reliance on these later events is really just a smokescreen.
How does an attorney help veterans in understanding the full scope of the benefits that are available to them and that they might be entitled to?
Well, obviously, one of the things that we do is to look at the entire file, every claim that's ever been made, whether it was granted or denied, and look to see what the possibilities are. For example, say you have someone who has been granted service connection for their back. Now, many times, the VA fails to note that the person has related physical problems. Most commonly, for example, radiculopathy going down the legs. That just means pain that follows the path of the nerves from the back down into the legs. Sciatic pain most commonly, but it can be other kinds. And the veteran is entitled to separate compensation for that. The VA often fails to note it and often fails to compensate the veteran for it. And sometimes it's much more basic. For example, Alexandra had a case a year or so ago where she was meeting with the veteran to prepare his case for hearing on his mental health claim. And they got talking about his current medical condition and reviewing the records. And she saw that he'd been diagnosed with diabetes. And this is a Vietnam-era veteran, so diabetes is a presumptive condition. The veteran didn't know that diabetes was presumptive from exposure to Agent Orange in Vietnam and hadn't made a claim. So she explained it to him and he put in the claim, and of course it was granted because it's presumptive. But it's that kind of thing. It's getting the information to the veteran about what are potential claims and getting the information to the VA about what's going on with the veteran. And, we've been doing this for a long time. I've personally been doing this since 1991. And so over that period of time, I and others in the office have seen almost every issue that can arise in the VA context. And so we can help veterans spot those issues, explain how it all goes together, get the claims in, and get them granted slowly.
Well, and one question I did want to ask too, because it's a question we get a lot from potential clients, is what strategies and methods can an attorney bring to bear to try and expedite the slow VA process? Because, really anybody claiming that they can speed up a VA disability case is
probably not being truthful, yeah. And unfortunately, there are a bunch of scammers out there who tell that story to people and then just take money. But that's a different thing. In terms of expedited claims, there are a couple of ways that you can go about it. One is there is a formal process with VA for expediting claims, and that requires you to meet their criterion. For example, if you're 75 or older, the Board of Veterans Appeals will expedite your claim. If you are diagnosed with a fatal condition, the VA will expedite your claim. And sadly, we use that more than I would like. It's very unfortunate, but that happens. Additionally, the VA will expedite the claim if you're homeless, and many veterans who are seeking benefits are, in fact, in that sad state. And the VA will also expedite your claim if you are having financial difficulty, but that one is much harder. Essentially, it typically requires proof of filing bankruptcy to persuade them that you truly are having financial difficulty. But there are those possibilities. The other ways that we can expedite the claim are making sure that the appeals are filed in a timely fashion. Most VA appeal periods run for 1 year. So you can file a timely appeal on day 365, but you've saved the veteran 11 months if you file on day 30 instead of day 365. So obviously we try to do that to expedite claims. The other things that can be done to expedite claims are simply getting the information to the VA in a more rapid fashion. If the VA has to wait for pieces of information, that just slows things down. So the more that information can be provided so that they can act on claims, the better. And there are a couple of other things that we've done over the years that sometimes work. I certainly wouldn't want to claim that they always work, but sometimes inquiries to the senator from, or a senator from the veteran's home state will prompt the VA to move a little more quickly. We've had a couple of folks who've had success with letters to the president, both the current president and earlier presidents, have sometimes been successful in moving claims a little bit. But primarily it's just knowing the grounds on which the VA will expedite and making sure that we bring those to bear whenever they're available.
This next question is near and dear to my heart, just from my own experience and practice doing veterans disability claims. But in what ways does an attorney help to clarify or rectify misunderstandings in a veteran's medical records or service records?
Well, as you know, VA records, particularly older records, are not always all that clear. And that can be both in the literal sense of old handwritten records that are hard to read, or it can be in the sense of information that's in the records but is overlooked by VA. That's a common problem. VA will say, well, there's nothing in the records to indicate that you had high blood pressure in the service. But when you go back through the records, in fact, there are multiple entries showing pressure readings that are elevated, and they've just overlooked them. So part of it is simply finding what's actually in the records. But part of it is also getting experts to explain the significance of things that the VA sees but doesn't appreciate the significance of. We were just working on a brief yesterday. The VA had rejected a mental health claim, and we got a report from a psychologist who explained that while there was no record of active mental health treatment in the service, the person had come into the service and functioned at a pretty high level. And then at the point he was saying he began to experience problems, what you saw in the records was a dramatic drop in his level of performance. And the psychologist was able to tie those things together and explain to the VA that the reason for the sudden drop in performance was the mental health symptoms that he was explaining he started to experience at that time, and that the drop in performance is what demonstrates the existence of that problem at the time.
Many of our clients at some point over the course of their claim will get scheduled for a CMP exam. What is the attorney's role when somebody's scheduled for a CMP exam? How can an attorney help in that instance?
Well, there are multiple ways, and it varies obviously from case to case. But one thing that the attorney can do is to simply talk with the veteran and explain what the important issues are in the case and what facts it's important to make sure the examiner is aware. That's one. A second one is to advise the veteran that there are certain documents showing those important things that he or she should take to the exam and literally show to or give to the examiner. And there are multiple examples, but you get the idea. The point is to understand what the claim is about, what facts are relevant to the claim, what needs to be conveyed to the examiner, and making sure that the veteran has that information at hand, whether it's in terms of giving an oral history to the examiner or whether it's providing documents or some combination of those.
We're almost out of time for today, but I wanted to end with this question. How does an attorney's intervention improve the accuracy of disability ratings?
Oh, it improves it a lot. I mean, not sure how best to say this, but the biggest problem in these cases is that veterans aren't trained in presenting information in a way that matches up with the VA's compensation claims system. And attorneys are. And so it varies in terms of what you need to do in each case, but what is always important is to understand what the claims are, to understand what is required to prove those claims, and then to assemble that information within the veteran's particular framework, whether it's proving a fact like the car accident in Germany, or whether it's proving that he really had back problems before the industrial accident in 1994, so that can't be the cause of his back problems because they existed before that. or any number of other examples. But the critical thing is to bring to the process the understanding of how the claim system works and what has to be shown to the VA, and then assembling that information to show it to the VA. And it can take myriad forms, but it's that same process over and over.
One situation that I've encountered in many cases is where a veteran will have a symptom that's causing them extraordinary pain. It's what they think about day in and day out, but for whatever reason, the rating available to them for that condition is not going to net them the most benefits, whereas the mental health condition that they see as just the baseline, the way it is, I've been dealing with this for years, they don't even think about it, is what's going to push them, over the line to get a TDIU, a total disability for individual unemployability. Really the lawyer's ability to take a step back, they're not living in those conditions day to day, and look at not just what hurts, what the big problem is, but what will get them the most benefits at the end of the day.
I had a case years ago where a gentleman was diagnosed with prostatitis while he was in the service. And while the rating for that is not particularly high, as you point out, it has significant mental health effects for a lot of people, and in his case it did. And it was actually the rating for the resulting mental health problems that got him the benefits that he really needed.
Well, thank you for tuning in to another episode of Victory Over the VA. Please be sure to subscribe and join us next week.
We'll see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.